of today. In this particular session, I am going to discuss with you certain very important topics. Now, these topics that I am going to talk to you about, will deal with the various subjects of law, right? So, are we all ready? Are we all ready for this particular session? Waiting for your responses. Okay, so in this particular session, I am going to talk to you in details about AILET 2022. Now, I'm sure that you have worked hard for the last couple of months. You have put in a lot of energy in the last couple of months. Now, how should you prepare now? What are the things that you should do for a better preparation for AILET 2022? So, BYJU'S exam prep brings to you a non-stop marathon on legal reasoning for AILET 2022. A very good evening to all of you friends. A very good evening to all of you. Okay, I can see a lot of known faces. Anushka, Harshita, very good. Great to see you guys. Okay, let's move on. Now, let's first understand legal reasoning and the breakup of the topics. Now, legal reasoning has always been one of the most important subject for all law entrance examination, be it CLAT, be it AILET, be it Maharashtra CET, whichever exam you sit for, legal reasoning will play a very important role. Now, over the last couple of years, what we have seen and what we have analyzed through data, because we believe in data. Data speaks for itself. In the last couple of years, we have seen that from constitutional law, you get around 14.48% of the questions. So we have analyzed all these topics in detail and have seen how much percentage of the total marks come from which topic. So from constitution, you get around 15%. From law of contracts, around 20%. 20% is a big thing. Law of crimes, less, around 10%. Law of torts, more than 20%. Then from legal current affair, you get around 25%. And from miscellaneous topics, very close to 10%. So, law of contracts, law of torts, and legal current affairs play a very important and a crucial role insofar as your preparation for this examination is concerned. So, you can see it up there on the screen itself. These are the three important topics. Right? Okay, let's move on. Now, let's understand what are those important topics in constitutional law that you must be preparing for. Number one, judiciary. The role of the judiciary. Now, the judiciary includes the Supreme Court, the High Court, as well as the lower judiciary. Now, insofar as your examination for AILET is concerned, High Court and Supreme Court, you must understand the structure, how many High Courts are there in India, who is the Chief Justice of a particular High Court, okay? So, you must know the names of the Chief Justices of various High Courts in India. So, Chief Justices of various High Courts, very important. Of course, I am sure that you must be knowing the Chief Justices of India's name, Justice N.V. Ramana. Now, apart from that, you must also be aware of the role of the Supreme Court, the role of the High Court, the various jurisdiction, okay? The various jurisdiction. The various jurisdiction. What is writ? What is writ? What is an advisory jurisdiction? What is an advisory jurisdiction? What is an appellate jurisdiction? What is an original jurisdiction? So there are various jurisdictions of the High Courts and the Supreme Court. So I'm sure that you must pay a lot of attention to the various jurisdictions of the courts also. I'm just giving you an example called Writ plus original jurisdiction. Then you have advisory jurisdiction. So there are various jurisdictions, right? Now, this is what you should know. Apart from that, insofar as our Indian judiciary is concerned, you must also be aware of how are judges appointed. Okay? How are judges appointed? How are they appointed? How can they be removed? What are the provisions of law which deals with appointment of judges? I'm sure that you must be aware of the collegium system. The Supreme Court, it is the only Supreme Court in India, in the world, which appoints judges. In other jurisdictions, there has been a lot of debate. We had the NJAC, the National Judicial Appointments Commission. But that was struck down by the Supreme Court, by a constitution bench. So you should be aware of that. Then comes fundamental rights and duties. What is fundamental right? What is a breach of fundamental right? What are the various types of fundamental right? Right to equality, freedom, right against exploitation, right to constitutional remedies, right to religion. So there are a number of important fundamental rights that are enshrined under the Indian Constitution, right? So you must be aware of the fundamental rights. And another very important thing which I will tell you is that you must be aware of also that there is a reasonable restriction, right? Article 19 of the Indian Constitution, which gives certain freedoms, which deals with certain freedoms. Article 19 rights are not absolute in nature. These rights are not absolute in nature. They are subjected to something what we refer to as reasonable restriction, RR. Am I clear? Have I made myself clear to each and every one of you? So, fundamental rights, there are 6 fundamental rights. 6 fundamental rights, right? Okay? Now, apart from that, I was just forgetting, let me just remind you, insofar as the judiciary is concerned, you must know where is the High Court located. Okay? Now, you will also have certain states which does not have a High Court, or an union territory which does not have a High Court. For example, Goa. Goa does not have a High Court. So, which High Court has jurisdiction over Goa? Lakshadweep Island. Right? Now, Andaman and Nicobar, Lakshadweep, these do not have a High Court, but some High Court will have jurisdiction over it. For example, Punjab and Haryana has only one High Court at Chandigarh. So, all that I am trying to state is that you, when you are preparing for an exam like AILET, must be absolutely prepared in all ways possible. Apart from that, fundamental rights, you also have law of contracts. What is an offer? What is an agreement? What is an unilateral offer? What is consideration? What is lawful consideration? What is lawful object? What is a wagering agreement? And what is a conditional contract or a contingent contract? So when you guys are preparing for an examination like AILET, you must be very well prepared because you don't know from where you will be getting these questions from. Now, law of contracts is very, very important because it is a law that deals with transaction, okay? It is called a business law. It is a business law because what is the law relating to buying and selling of goods and services in the market? Okay, so I'm sure that you must be well prepared, and I'm sure that those of you who have attended our classes, our online classroom program, are absolutely aware of the various aspects relating to law of contracts, right? Apart from that, in law of contracts, you have offer and acceptance. What is an offer? I say I want to sell my pen for ₹10. So that is an offer or a proposal that I have made to someone else. What are the various types of offer? Specific offer, general offer, counter offer, invitation to an offer, invitation to an offer also. So if you guys have any difficulty even now, what you can do is that you can search and read up on the internet. There are ample of material up there on the internet which you can refer to and understand these principles very usefully. Okay. What is offer and acceptance? Then you have undue influence. What is undue influence? Now, we all know that when we enter into a contract, we enter into a contract by virtue of free will. We enter into a contract by virtue of free will. Now, if by any method your free will, you are not able to exercise your free will, you are not exercising your free will while you are entering into the contract, it is voidable in nature. Now, what is undue influence? Now, if someone enters into a contract by use of his position, by the use of his high office, if he is using his power, his official position to influence someone to enter into a contract, that is what we understand by undue influence. Okay? Then you must also think about breach of contract. Now, I and you, suppose, have entered into a contract. Suppose I have entered into a contract with you for buying certain goods. Now, suppose either of the parties, if they do not follow what they have promised to, then what are the consequences? What are the repercussions? That is also to be taken care of. So in this particular session, in this marathon session, we will try our level best to discuss with you most important topics insofar as legal reasoning is concerned for AILET 2022. Moving on. Apart from law of contracts, judiciary, and the Constitution of India, we also have law of crimes. Now, what is law of crimes? What is the nature of crime? What are the elements of crime? What is mens rea? What is actus rea? What is motive? What is intention? Those things which we have discussed in the classes, I want each and every one of you to go through them. And today, of course, we shall be discussing some very, very important questions in the course of this session itself. So guys, do stay tuned till the end of this session. What is attempt? What is bribery? What is negligence? What is cheating? We are going to understand these important topics by way of a question-answer round. Okay? Apart from that, we shall also understand the law of trespass, what is theft, and, of course, civil law. So, in law of crimes, we shall today try to answer certain questions relating to attempt, what is bribery, what is negligence, what is cheating, what is trespass. Now, trespass is of two types, mind you. What are they? The first one is called assault, and the second one is called battery. So we shall be understanding these concepts. What is theft? What are the ingredients of theft? Then comes law of torts. What is negligence? What is vicarious liability? The concept of vicarious liability, for which we have a nice question today for all of you. Now, what is the concept of vicarious liability? Generally, under the law, generally speaking, if I commit a wrong, I will be held liable. If you commit a wrong, you will be held liable. Now, here is a strange phenomenon whereby for the wrong committed by A is not held liable, but someone else is held liable. The person who has committed the wrong is not held liable, but someone else is held liable. How does that concept pitch in? This concept happens where for the wrong committed by the servant, if the servant has committed a wrong while doing an authorized act which the master has asked him to do, and if that wrong has been committed during the course of employment, who will be held liable? The master. The same principle applies to principal agent as well as partners in a partnership firm. So for the wrong committed by one of the partner, the other partners can be held liable. Okay? So are we all understanding these important things? Okay? Apart from that, we shall also talk about nuisance. What is nuisance? Causing any kind of disturbance. If by your action you are interfering with the good possession of someone's land. Now, suppose your neighbor wants to sleep at 10 o'clock in the night and you are playing loud music at 12 o'clock in the night, and as a result of you playing that music in such high volume, your neighbor is unable to sleep. So what have you caused? You have caused disturbance. You have caused nuisance. Okay? So please try to understand, friends, that in this session we shall be answering certain very, very important questions relating to all these topics. Okay. So, then from current affairs, we shall also have certain important things to discuss, and then recent legislations. Okay, recent legislations will also be very, very important for each and every one of you, because a good chunk of question in AILET comes from current legal affairs. Now, current legal affairs would include recent judgments of the Supreme Court, recent judgments of the High Court, and other legislations that are passed by the Parliament in the recent times. Now, one of the most important thing, I'm sure that you have been reading newspapers for some time long. Now, I'm sure that you must have heard about the very important judgment that was delivered by the Delhi High Court relating to marital rape. So, that is a cursor for you. You might get, of course, the judgment is a split judgment. The judgment has been a split judgment. One judge says one way, the other judge goes to the other way. So it's a split judgment and the matter is pending before the Supreme Court. But you must be aware of the facts, the law that is discussed by the High Court. Okay? So guys, let's move on. Recent appointments, very important. Some people have been appointed to constitutional bodies, constitutional authorities as chairman, as something else. So you must be aware of this also, recent appointments that have taken place in the recent past. Okay? Now, you have various appointments. And thereafter, you must also be prepared about miscellaneous topics, and finally, international law. international law, one more very important judgment coming from the ICJ was the Ukraine crisis, okay? Russia's invasion on Ukraine. The International Court of Justice has said Russia to stop the war. But Russia is not listening. So that was another very important intervention by the International Court of Justice. They might ask you who is the president of the ICJ, or who happens to be a judge from India who is sitting in the ICJ. So there might be a number of questions from international law also. In international law, in the year 2022 itself, a week back, in CLAT, you got around 5 questions, okay? One passage was based on international law. So international law will be important for you guys also, okay? So guys, let's begin. Constitutional law and the judiciary. So we have a question for you. Let's begin. Up there on your screen, guys, up there on your screen, okay? Up there on your screen, read, which amongst the following states does not have a high court? Is it Mizoram? Is it Tripura? Is it Meghalaya? Or is it Manipur? Which of the following? I would want all of you to give me the answers to these questions on the chat box of YouTube, okay? Yeah, which of the following states do not have a high court? Okay, people are saying A, C, B, A, C, okay, C. C is Manipur, okay. Manipur does not have a high court? I knew. Okay, let's see. Let us see the correct answer, and the correct answer is Mizoram. Mizoram does not have a high court. The state of Mizoram does not have a high court, okay? Very important, very important, guys, okay? Which state in the northeast does not have a high court? And the answer is Mizoram, okay? Write it down. Take notes of it fast. Moving on to question number 2. Let's read the question. Which of the following is correct regarding removal of a High Court judge? Which of the following statements out here is correct insofar as the correct position of the removal of a High Court judge? Let's read the first option. A High Court judge can be removed by a resolution passed by a general majority in the Parliament, okay? A High Court judge can be removed by a resolution passed by the special majority in the Parliament. A High Court judge can be removed by Chief Justice of India in consultation with the President. A High Court judge cannot be removed at all. Okay, now a High Court judge cannot be removed at all is not the right answer. A High Court judge can be removed by the Chief Justice of India in consultation with the President. Of course not. So we are confused between A and B, right? Okay, A and B. Which of the following is correct? Now, what you do when you get certain options is try to remove the incorrect options. Eliminate the wrong options first. Now, a High Court judge can be removed by a resolution passed by the general majority of the Parliament. General majority. I have heard about majority. I have heard about special majority. But I have never heard about something called general majority. But wait. A High Court judge can be removed by a resolution passed by a special majority in the Parliament. Okay, now I understand. There is a difference between general majority, that is normal majority, and a special majority. Okay, very good, very good. Most of you are giving me the right answer. The correct answer is option B. By a special majority, he can be removed. Okay, by a special majority. By a special majority. Please note it down. Very, very important, guys. It is by way of a special majority. Okay. Fantastic. Khushbu Tiwari. Fantastic. Okay. Shrestha Singh, Satvik, Raju. Fantastic. Great to see you guys. Wonderful. Chalo. Let's move on. Let's move to the next set of questions, okay? Constitutional law, fundamental rights and duties. Now, I'm sure that, okay, I have some questions for you. Which part of the Indian Constitution deals with fundamental rights? Which part of the Indian Constitution deals with fundamental rights, guys? Which part? Which part? Okay, which part of the Indian Constitution deals with fundamental rights? And the correct is part 3. Very good, very good, very good. Part 3 of the Constitution deals with fundamental rights. Okay. Okay, let's start with the questions. Read it. Okay. Okay. There's a provision of the Indian Constitution which says, that is Article 20, Subclause 1, which says that no person shall be convicted of an offence except for violation of a law in force at the time of commission of that act. Suppose a law is not made. Suppose a law is not made by the legislature. Suppose relating to money laundering, for example. Just giving you an example. Suppose the parliament has not framed any law relating to money laundering. Now, can you or can Mr. A or can Mr. B tomorrow be prosecuted for money laundering? No, of course not. How can he be? There is a vacuum in the law. Where there exists a vacuum in the law, I cannot be prosecuted for that. Let's continue reading. Or be subjected to penalty greater than which has been provided under the law. Now, suppose the law says for murder, for example, for committing theft, you will be imprisoned for 3 years. Suppose the legislature, the parliament has made a law. Example. It's not true. Suppose a person commits X offense, he will be punished for 3 years. Suppose Mr. A has committed X offense. Can he be punished for 7 years? Can he be punished for 7 years? No. So that is what this principle deals with, right? Let's read the facts. R was charged for an offence punishable with imprisonment for 1 year. The magistrate convicted him and ordered 1 year imprisonment. While R was undergoing the sentence, the law under which he was convicted got amended. Now, after he has committed a crime, after he was punished, the law under which he was punished was amended, and the punishment of the offence was reduced to 6 months. Very important. Accordingly, the defense filed an application, the defendant filed an application, the accused filed an application to the magistrate for review of the sentence and to commute it to 6 months. At the time when he committed the offense, the punishment was 1 year. When he was given that sentence, When the magistrate gave him 1 year, the law was subsequently changed. And as a result of this particular amendment, the punishment was reduced from 1 year to 6 months. Right. Now, can the application asking to commute his sentence from 1 year to 6 months be allowed? Let's see. It cannot be allowed because penal laws have prospective application. Okay. It cannot be allowed because penal statutes cannot be given retrospective effect. Okay. It cannot be allowed because at the time of coming into force, the amendment laws was already undergoing the sentence. And option D you have, it can be allowed. It can be allowed, it says. Because retrospective application of criminal law is permissible if it is beneficial to the accused. If it is beneficial to the accused, then that benefit can be given. Okay. Now, if you read the principle very carefully, okay, some of you have given me the right answer. Some of you have given me the right answer. Let's see. Should it be allowed? Should it not be allowed? And the correct answer is it can be allowed because retrospective application of criminal law is permissible if it is beneficial to the accused. In case it is beneficial to the accused, then the application might be permissible. Now, if you think in those grounds, look at the sedition laws. The Supreme Court has put the sedition law on hold, has put the law of sedition on hold, right? And what did the judge say? The 3-judge bench headed by Justice Ramana say? It said that from now onwards, no police station will file FIRs, will entertain FIRs under this provision of law, and has also given an help to the accused, to those who were being punished, saying that you can show this order, show the order of the Supreme Court before the trial court and get a bail based on this order. So, please try to understand that this particular law is very important. You can definitely take advantage of an amendment which is beneficial to you. In criminal law, it is allowed. Okay. Yes, it is 124A, Navya Rastogi. Okay, fantastic. Okay, let's move on. Question number 2. I don't think I should give you any option. The Supreme Court has the power to issue writ under which article? Okay, the Supreme Court can issue writs under 32 and the High Court under Article 226. Very, very important. Note these are certain important things that we are talking to you about. The Supreme Court is empowered to issue directions or orders in the form of writ, in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, right? For the enforcement of rights that are conferred under Part 3 of the Constitution, that is fundamental rights. Okay. Z was illegally detained. Now, wherever there is an illegal detention, suppose a person has been illegally detained, which writ should be filed in the court? Have the body. Okay, have the body means, right? Let's see. Now, habeas corpus, so you can chuck these two away. These are two questions. These are the two options, okay? You have to remove the wrong answers first and foremost. Now, is option A correct or is option C correct? Tell me. Which option is the correct option? A. Okay. Most of you. Now, Z is in custody. How can he go and file? It has to be filed by the relatives of Z. Okay? You had to be that much smart. Okay? So, these exams also want students to be street smart like you guys. Fantastic. Okay. So, he cannot file it because he has been illegally put under detention. Somebody who he knows. So, his relatives. His son, mother, father, husband, wife, whoever. Okay? So the correct answer is option A. Okay. Are we done? Moving on to the next questions, which deals with law of contracts, offer and acceptance. Okay, so now we are going to start answering questions relating to offer and acceptance. Okay, let's begin without any delay. Let's read the principle. A proposal or an offer is said to be accepted when the person to whom it is made signifies clear and unequivocal assent thereto. So, if I make an offer to you, if I say I want to sell my pen for ₹100, suppose you keep quiet, how do I know what is there in your mind? Have you said a yes or a no? Same thing. A invites B for dinner. In the meantime, A makes an offer saying, I want to sell my black car for 40,000 rupees. To which B says nothing. B has kept silent. He has neither said a yes nor a no. Later, A sues B for the breach of contract, stating that her silence is equal to acceptance. Silence is equal to acceptance is the argument of Miss A. Decide whether B is liable or not. Okay. Let's see the answers. Okay. Okay, B is liable. So, right? So we are discarding the wrong answers. Now B is liable, B is not liable, B is not liable. Okay. Because the acceptance was conditional, because she never accepted the offer. It is an easy question for you guys. So, guys, I'm sure all of you are giving me the right answer. There is no doubt about it. This is the right answer. This is the right answer because that woman has not accepted the offer itself. She kept silent. Now, how does the person who makes the offer know whether she has accepted it or rejected it? Right? So, the correct answer is B is not liable because she never accepted the offer. So guys, are you understanding how to solve these questions? Are you able to understand? Okay? Okay? Fantastic, fantastic. Great to see you guys. Okay. Any doubts till here? Any questions? If you have any doubts, please let me know. No, I don't think, Anamika, the questions I don't think will be very easy. I'm sure that you must have gone through the CLAT 2022 question paper. It was not very difficult, not very easy. It was moderate, but at the same point in time, it was a lengthy paper. Okay? CLAT 2022 was a lengthy paper. Okay? Okay. Let's move on to the next question. Question number 2. Let's understand the principle. An acceptance to an offer must be absolute, unqualified. That means if I make an offer to you, either you accept it or you reject it. If you are making a counter offer to me, that is not an acceptance. A counter offer is not an acceptance. Keep that in your mind. Suppose I say, I want to sell my pen for rupees 100. You say, sir, I can't buy this pen for 100. I don't mind if you sell me for 90. Am I bound to sell it to you for 90? No, I am not. Because the next offer, any amendment to the original offer amounts to a fresh offer. Okay? A invites B to his home for dinner. In the meantime, A makes an offer saying, I want to sell you my only horse for 40,000. Horse. B replies, 40,000 is too expensive. I don't mind buying the horse for 20,000. So an offer is made for 40,000. He says, no, I don't mind buying it for 20,000. Later, A sells her horse to C for 20,000. Now, A and B, was there any contract between A and B? Was there any contract between A and B? No. Now, A later on sells it to C for 20,000. How does it matter? Was there any contract between A and B? There was not even an iota of doubt that there was never any kind of contract between A and B. Decide whether A is liable. Let's see the questions. Answers, sorry. A is liable. A is liable. A is liable. A is not liable. Am I clear? See, the questions are not difficult. If I am explaining you in a manner in which you understand these things, then it becomes easy. But the challenge will be, now let me pause over for a minute and tell you. The challenge for you will be that during that examination, nobody will be there to explain you the principles, the factual background and the options correctly. Now, the manner in which you should read a question, you should come to know the answer itself. Am I clear? Is that clear to all of you? The manner in which you read a question, and that's why I always say, read, and read. If you have good vocab, if you have good understanding of the law, you need not worry. take my word, you need not worry. If you have little bit of logical sense in your mind, you need not worry. Okay? So the correct answer is option D. Very good. Automatic, option D. Okay, fantastic, fantastic. Great, great, great. Great to see you guys. Great to see you. Moving on to the next set of questions, which are based on law of contracts itself. Undue influence. Now, what do you mean by undue influence? What do you understand by undue influence? Now, generally the law says that whenever we are entering into a contract, we are entering into a contract by virtue of free will. So you have a free will to enter into any contract you want to. Suppose tomorrow I want to buy a uni ball pen, right? Can you tomorrow say, no sir, you cannot buy a uni ball pen. You have to buy a Parker pen. No, it's my choice. It's my wish. Now, generally, the law of contract simply says that whenever we are entering into a contract, we should enter into a contract by way of our free will. Now, there are certain circumstances whereby we enter into a contract without our free will. One is coercion, use of physical force. The other one is undue influence. Of course, there is misrepresentation, fraud, and mistake also. Now, what is this concept relating to undue influence? Now, undue influence says that if you are forced to enter into a contract by a person who is using his chair, his power, who is using his chair or his power, that is called undue influence. If you are forced to enter into a contract owing to the fact that somebody is using his position, his power, not physical power. I'm not dealing with physical power over here. I'm talking about the power of the office, the power of the chair. That is called undue influence. Let's move on and see the questions we need to solve over here. Contract is an agreement which is to be entered freely, okay? Freely entered into between the parties. But when consent to an agreement is obtained by undue influence, the contract is voidable at the option of the party whose consent was obtained under undue influence, right? Let's read the facts. Okay. was working for B, a businessman for a long time, 2002. B's business was facing financial difficulties and he asked A to offer her flat as a financial security against the overdraft facility for the business. In July that year, the bank solicitors advised A to take independent legal advice before putting the property up for security for the debt. So, the bank solicitors, the bank officials had asked this person that before you go for this financial security that you are giving, please take some legal advice. The bank also notified that the guarantee was unlimited in both time and financial amount. A, being unaware to the extent of the debt, discussed the agreement with B and was assured that the mortgage would not be called upon as A's property, which were also being used as security, would be looked at first. A charge was executed over A's property. Thereafter, the business went into liquidation and the bank formally demanded 60,24,912 rupees from A. This was the background on which the security of the flat was handed over to the bank with regards to a loan. Okay? Now let's read the options. Let us read it, guys. Okay, people are saying B, A, D. Okay, let's see. The bank had not taken all responsible steps to allay concerns of undue influence. The bank had taken all reasonable steps to allay concerns of undue influence. A had the duty of being aware of the undue influence. Now, okay, all in one says A. Okay. There are people who are saying A also. Let's see the correct answer. And the correct answer is option A. Now the question over here, now these are little technical questions. Now you have to first understand one basic concept. Now, based on these facts, some people might say, sir, where is undue influence? Is the bank responsible? Is the bank not responsible? Now, the bank did advise this person to take a legal opinion. Fair thought. But at the same point in time, it was a duty of the bank people to explain this man that this particular mortgage of the flat is for an, what does it say? The words. What is that word which is used? Tell me. Advise the bank to take independent steps, and thereafter that he did not had the understanding. Very important, okay? A, being unaware of the extent of the debt discussed in the agreement with B. That means he was not aware of certain things. Now the question is, was it not the responsibility of the bank to tell this man about the entire agreement? He did not have the knowledge about certain facts. And henceforth, option A is the right answer. Okay. Moving on. Question number 2. A 22-year final year student of law, did not perform well in the previous semesters. Mr. B, who used to teach law of contracts, very, very important, asked her to buy his flat in double of their market price. If you buy my flat double the price of the market value, then he will get a passing mark. That means here is a student who has failed in his exam, in her exam. Now, having failed in the exam, the teacher says, okay, I have a flat, I want to sell it. If you buy my flat for double the amount, I'm going to make you pass. That's it. That's it. Okay. So a contract was entered into. Now decide whether this contract was entered into by undue influence or not, right? Let's see the options. A's consent was not obtained by undue influence, wrong. A's consent was not obtained by undue influence, wrong. A's consent was given freely to bribe the administration, okay. A's consent was obtained by undue influence. So you have option A and option D, right? B and C is out, okay. Which of the following is the correct answer as per the principle, as per the facts? Okay, the correct answer is the consent was obtained by undue influence. Am I clear? The consent was obtained by undue influence. Okay, fantastic. Okay. Moving on to the next question. Breach of contract. Okay. Let's read. Okay. ABC Tour and Travels agreed to employ R. So here is an agreement between Tour and Travels guys and R as his courier for 1 year. Okay. 1st August 2020 to 1st August 2021 for a trip to New York. On 10th of May, ABC Tour and Travels wrote to R stating that his services are no longer required, that your services are no longer required. On 22nd of May, R sued ABC Travel Company for breach of contract. ABC Tour and Travels argued that R was still under an obligation to perform his part and therefore could commence no action before August 1, 2020. That's what is provided, right? Now, there was an agreement from I think it was August, right? 1/8/2020 to 1/8/2021, right? And in the middle, the contract was repudiated. The contract was repudiated. Now, can he go to the court? Can he not go to the court? A breach of contract by renunciation duty to future obligation does not render party liable. Does not render a party liable immediately to a suit. No. Renunciation of a contract for future conduct by one party immediately dissolves the obligation. Immediately dissolves the obligation of other party to perform that contract. Okay. The offer can be revoked anytime before 1st August 2021 and R cannot claim any damages. No. A contract for future conduct do not constitute an implied promise that in the meantime neither party will prejudice the performance of that promise. Which of the following is the right answer? Option B. Option B is the right answer. Option B happens to be the right answer, guys. Option B. Is that clear? Option B. Good, good. Moving on to the next question, question number 2. Right, A agrees to sell 20 kilo of oranges to B, knowing that B uses the fruits to run his juice center. Right. A supplies substandard quality to B. However, none of the customers are able to differentiate, are able to understand that this juice is made out of substandard oranges. The question is, can B recover damages from A? The contract relates to supply of oranges. Has anywhere in the question it is mentioned that I want Kinnor apples, I want Kashmiri apples? Nothing. Does it talk about anything like, okay, I want Nagpur oranges, I want Uttar Pradesh oranges, I want Karnataka oranges? Does it say about quality? Have you been told about the quality in the factual situation itself? Okay, so the correct answer, A can recover damage for supplying substandard quality. No. A cannot recover damages from B since he suffered from since he did not suffer from monetary loss. He cannot. No, monetary loss, if there is a violation of a legal right, if there is a breach of contract, whether you suffer loss or no loss is not the question. Your rights, if they are violated, you can go to the court. A cannot recover damages from B because the contract did not prevent supply of substandard quality of oranges. The contract did not deal with supply of substandard materials. A can recover damages from B because the contract prevented supply. Contract prevented supply of substandard quality of oranges. Where does it say so? So the correct answer is option C. Option C is the right answer, guys. Yes, very good. Asim Khan, Bhavna, Oshini, Ruhi, Prachi, violate. Very good, very good. Okay. Moving on to questions relating to law of crimes. Questions relating to law of crimes. Attempt. Let's see. These two are not punishable, whereas attempt and commission is punishable. Okay, keep that in your mind. Attempt and commission is punishable. Acts done must be sufficiently proximate, close to the accomplishment of the intended offense. We are dealing with attempt. Which of the following is an attempt? R, in order to forge a document to be executed by S, sends his servant to buy stamp paper. Preparation. R shoots S, but S is not hurt because he was beyond the range of the gun. So you fire the gun, the bullet does not reach a particular point, but you have fired. So this is a good answer. Let's move on to option C. R pours half a pint from bottle to poison into S's drink. You have put that thing, you have put some poison in someone's drink, but he has not attempted to drink that bottle from the bottle, so it's not an attempt. Okay, R gives a noxious substance to S to get her child aborted, but S was not pregnant. Okay. So, which of the following is the right answer? And the correct answer is option B. See, the best answer, now there might be one or two good answers, okay? You can also, if there were bad answers, then C could have been a better answer. D also could have been a better answer. But out of this 4, the best answer is option B. Option B happens to be the best answer. Okay? Is that clear now, all of you? Moving on, law of crimes, bribery. Now we shall be dealing with bribery. Let's start answering. So here is a poor man. He cannot afford a particular surgery or an operation. So here is a man who goes and to help the person who is ailing. And he says that, okay, I am going to give you the money for the operation, provided your entire family votes for me. Whoever gives a gratification to any person with the object of inducing him or any other person to exercise an electoral rights, or for rewarding any person for having exercised any such right, commits the offense of bribery. Right? Right. Very good. Question number 1. R has committed bribery, R has not committed bribery, R has not committed bribery, none of the above. If you know how to read the principle and understand the principle, if you know how to read the principle and understand the principle, things will not be difficult for you. Very good. Right? Everyone with me? Fantastic. Each and every one of you are giving me the right answer. Fantastic. Lovely, lovely. R has committed bribery. You don't have to see. You have to be smart. Now, you will not have great amount of time. You are not reading newspapers, right? You have to answer question fast and move on to the next question. So first read R has committed, R has not committed, R has not committed, none of the above. Cancel the wrong answers. Come to the right answer. That is how you must attempt these questions. Moving on to law of crime, negligence. So what exactly is negligence? Let's find it out by way of an question answer round. Okay. Negligence is a legal wrong that is suffered by someone at the hands of another who has a duty of care. If I have a duty of, suppose I am a doctor. Suppose I am a doctor, I have certain duty of care towards my patient. Now suppose I do not do what is required under the duty of care measures. I do not take those precautions. And the patient is hurt. His rights are violated. Owing to my negligence, because I had a duty of care, I did not hold my duty of care properly. I did not do my duty of care properly. For example, a bus driver has a duty of care to drive the bus carefully so that the passengers are not injured. Right? A lawyer has a duty of care towards his client. Right? Next principle. The test of liability requires that the harm must be reasonably foreseeable. Result of the defendant's conduct. A relation of proximity must exist and it must be fair, just and reasonable to impose liability. So, here is the relationship of proximity. How close is the negligence and the harm? How close is it? R's father died as a consequence of an empty oxygen cylinder. Wonderful. Provided to him in the hospital. The hospital has provided an empty cylinder. Owing to that empty cylinder, someone dies. He was admitted and suffered from COVID-19. R brought an action against the on-duty doctor for medical negligence. An empty cylinder was given to a COVID-19 positive patient. That is what this question, the facts, deals with. Okay. Read the options very carefully. R will fail against the on-duty doctor but will succeed against the nurses. Where comes the does not deal with nurses, the facts. R will succeed against the on-duty doctor. R will succeed against the on-duty doctor and the hospital authority. Let's see. Now, now the question is on-duty doctor. Who is the doctor on duty? Is he liable or is the hospital authority liable? The question is this. Wait, before you answer. Who is liable? Is the doctor on duty liable or is it the hospital authority? And the correct answer is option A. R will fail against the on-duty doctor, but he will succeed against the hospital authority. From the given facts, we don't know where was the on-duty doctor, was he there or was he attending to someone else. But definitely we can make sure one thing, that the hospital authority is definitely liable. The hospital authorities are definitely liable, right? Everyone, right? Okay. Moving on to law of crimes. Another question on cheating. Let's understand what is cheating by answering the next question. I'll just move out of the screen for some time. Deceiving means, the principle of cheating means that if you are fraudulently, dishonestly inducing a person, if you are inducing a person fraudulently as well as dishonestly to deliver any property which he would not have done under normal circumstances. Under normal circumstances, he would not have delivered those properties. But because of your deception, because of your fraudulent activity, you have ended up selling or getting some movable goods. A shopkeeper puts a counterfeit mark of company X on the products of Y. So, it might be that the company X's products are superior, they are more costly, and Y's is a little less. So what he does, he is using fraud marks, deception, dishonesty to induce people to buy his products of X company, right? Now, when B went to the shop to buy the product of X company, what he does is on the product of Y company, he uses that X stamp or the mark. Now the question is, decide whether A has committed the offense of cheating. Simple, not very difficult. Let's see. A has committed cheating, A has not committed cheating, A has not committed cheating, A has committed cheating. Okay, I think A has committed cheating. So option B, option C strikes away. A has committed cheating because he has forced B to buy the product. Forced B? Okay, because he induced B to buy a counterfeited product. Okay, he has induced B to buy a counterfeited product. So, yeah. Elimination of wrong answers. A has not committed. That's enough. Because you don't have to read all these things. Don't waste your time reading unnecessary stuff. You have to be smart. Okay? Is that clear to all of you? Any doubts? So I am sure that you are able to understand how to solve questions. Moving on. Law of crimes, trespass. Let's understand trespass by answering a question. Okay? Are we all ready for this? Are we all ready? Okay. Okay, fantastic. Let's move on then. Invasion of private property, however minor, in a trespass unless it is expressly authorized by law. Okay. If it is authorized by law, you can. A police personnel may enter search private property on an express authorization by a judicial officer. Okay. A vocal critic of certain policies of the Queen was about to load a protest against the prevailing government's policy. On the instruction of the Queen herself, the police officer secretly enters A's residence to search through her computer and discovers her plan for the protest. However, her laptop was at the repair shop and the police officer was forced to exit A's house after a few seconds. Miss A seeks to sue this police officer for committing trespass. Is that clear? Okay. Read the principle. An invasion of private property, unless authorized by law, a police personnel may enter search property on the express authorization of a judicial officer. On the express authorization of a judicial officer. Judicial officer. Who has authorized? The authorization was given by the Queen. Was given by the Queen. The authorization was granted by the Queen. Is the Queen a judicial officer? The question is simply this. Is the Queen a judicial officer? A will succeed because the Queen was planning on quelling dissent through illegal means. No. A will be unsuccessful because the search was authorized by the Queen, not a judicial officer. A will be unsuccessful because the entry of the police constituted an invasion of personal property without the authorization of a judicial officer. Fantastic. So the correct answer is option C. Very good. Very good. Very good. Okay. All of you, fantastic, fantastic. Great to see you guys. So keep liking the session, guys. Keep liking the session. Do share this session with your friends so that all who are interested for AILET 2022 gets maximum help from BYJU'S exam prep. The next question, question number 2. A entered his friend's B's garden, which was adjoining C's home. From B's garden, A insults C. A insults C. Right? That's the facts. Let's read the questions. C will succeed. Now, has he entered into C's land? The question is, has he entered into C's land? Now, you are staying in your land, in your property. You have not entered into someone else's property. Law of trespass says you have to enter into someone else's land. Where have you entered into someone else's land? Where? So the correct answer is very good, very good. The correct answer is option C. Very good, all of you. Brilliant, bingo, lovely. I'm very happy. I'm very happy for the fact that you guys are answering questions very well, okay? Very good, very good. So keep on sharing and liking this session. Moving on to the next important topic, law of crime, theft. Let's understand theft by a question. Whoever takes a movable property out of the possession of any other person without that person's consent, moves that property in order to such taking, has committed theft. Now, always remember that in criminal law, there is mens rea as well as actus rea. Two important things. Mens rea is your guilty mind, actus rea is your guilty action. Mens rea is your guilty mind, and actus rea is your guilty action. Both must be present for constituting a crime. Keep this in your mind. A has committed theft, A has committed theft, A has not committed theft, A has not committed theft. A has not committed theft. Now read, because both are iPhones, because he took B's phone by mistake. Absolutely, so option D is the right answer. Automatic. So read the principle, understand the law, apply the law, and you will be absolutely clear. Everything will be clear to all of you. Everything will be clear. If you know how to read, how to understand these important things. Okay? Are we clear? Moving on. Question number 2. Same principle. If you intend to take dishonestly any movable property outside the possession of any person without that person consent, you have committed theft. A likes B's diamond ring and decides to take it away. In fear of getting caught, there might be some CCTV camera somewhere. He hides it inside the carpet so that he can take it away when no one is looking. While leaving his B's house, A forgets to take the ring with him, decides whether he has committed the offense of theft. Whether he has committed the offense of theft. He is hiding that ring inside the carpet so that later on he can come back and just take it away. Okay, the options. A has committed the offense, A has committed the offense, A committed the offense, A did not commit the offense, okay? Okay, option D is over. A has committed the offense of theft the moment he liked the ring. The moment he liked the ring. Just because I like a ring, I have committed theft. No. A committed the offense of theft the moment he touched the ring. Okay. Hang on. A committed the offense of theft the moment he moved the ring. The moment he touched the ring, the moment he moved the ring. The moment if you take away a movable good, if you are trying to take away a movable good, so the correct answer is that clear? Are you understanding how to solve these questions, friends? Okay. So are you understanding, guys? Okay. Okay. Fantastic. Lovely. So, legal reasoning will not be difficult, and AILET has very categorically stated that they will not ask any questions on legal reasoning, but in your logical reasoning section itself, there might be questions where there would be application of laws. For which reason you must understand the laws. Okay, let's move ahead. Law of torts, negligence. Let's answer certain questions on negligence. Okay, let's get started, guys. Let's get started. Negligence principle has already been explained to you in the previous classes. Now here is an 80-year-old clock building which collapses in a crowd, killing 20 people. Generally, the lifespan of a clock building is 40 years. This is going on for 80 years. The legal representative of R sued the municipal corporation of the city for negligence because the tower was under their control. Was it negligence on the part of the municipal corporation? Did the municipal corporation had any duty of care? Was there any breach of that duty of care which was entrusted on the municipal corporation? Okay, is it a case of negligence? This is not a case of negligence. Strike out. Case of negligence, because municipal corporation had a duty towards all the accidents happening in the market. Okay. This is a case of negligence because a municipal corporation had a duty of care towards the citizen. Okay. So the correct answer is... Am I clear? Are you understanding, guys? Fantastic, fantastic. Question number 2. Okay. Okay. The third principle, insofar as the various principles of negligence are concerned. There are 3 principles: test of liability, the claimant, and the duty of care. These 3, very important. Read it carefully. Okay, done. Okay, fantastic. The final 4th important principle: conversation between a doctor and a patient are generally confidential, but there are few exceptions. Let me just move out of the screen for the next 30 seconds so that you can read it. Okay? Is that clear? Done reading. Okay. Done reading. Okay. Let's move on. Question number 2. No duty of care. Dinesh is not liable as it is a case of pure economic loss. No. There are circumstances where an auditor will owe a duty of care in respect of the reports produced. There are conditions that at the time the report is prepared, it is known by the auditors that the results are for a specific class and for a specific purpose. Option D, an ability to foresee indirect or economic loss to another person as the result of a defendant's conduct automatically imposes on the defendant a duty of care to avoid that loss. Okay. Very good. Mosvi Malik, very good. Option D. It is option D. Mosvi Malik, very good. Now, it is the ability to foresee. What are auditors there for? Why do we have auditors? Why are every company paying auditors fees? Huh? Why? Must be some reason. Right. That is how. Little difficult question. I would mark this question as a little difficult question, but not very difficult also. It is solvable. Okay. Moving on. Vicarious liability, the concept of vicarious liability. Right. Right. He sees so much of wastage of food. He is very disappointed. He sees so many poor people in and around who are driving for food, who are dying for food. Gets home, gets drunk, and negligently caused fire in his home. Is the employer liable? During the course of employment, mind those words which are provided over there. The restaurant is liable. The restaurant is liable. The restaurant is liable. Is the restaurant liable? Thank you. That is how you must answer the question. He goes back home. Where is the course of employment? Where is the course of employment? Right? Very good. Very good. Moving on to the next question. Guys. Moving on to the next question. Okay. A was employed by B to drive his bus. One day he asked C. A asked C, the conductor, to park the bus. As a consequence, the conductor caused an accident injuring R. R wishes to sue B for the accident. Okay. What is the duty of the driver? What is the duty of the conductor? Bus. That's it. B is liable, B is liable, B is not liable, B is liable. Not liable. Not liable. B is not liable. Very good. Outside the course of employment. Outside the course of employment. Okay, is that clear? All of you? Moving on. Nuisance. Let us now understand the law of nuisance. Question to nuisance by answering certain questions. Okay, up on your screen. Playing loud music in the middle of the night. Playing loud music in the middle of the night. You are causing disturbance or unreasonable interference with the enjoyment of the other person's land. R had a floor meal in the village. S purchased a home right on the edge of the meal. It causes hardship to S because the vibration was so much that it started disturbing his basic daily schedule. He sued R, who takes the defense that S had brought trouble on his head. Now, that is a defense, okay? Now, there is a big floor meal, it makes a lot of noise. It makes a lot of irritating noise. Now, the question is, does this fact amounts to nuisance? Now, let me tell you that these are little tricky questions because you might feel that, sir, whether the sound that a floor meal brings, is it unreasonable interference or is it reasonable interference? Okay. She will be unsuccessful, she will be unsuccessful, S will be unsuccessful, S will be unsuccessful, S will be successful. S will be unsuccessful, okay? So S will be unsuccessful. Because it is his fault that he purchased a home on the edge of a floor mill. Even though the ground is the source, the machine is the source of the interference, it is not an unreasonable interference. Now, out of these two options, what we feel is option C, the right answer. C is the right answer for one reason. Now, this part, option C, happens to be the right answer owing to two facts. Now, floor meal sound. Now, there is two types of answers which are provided. Now, there is two schools of thought in it. Now, at times, from the question paper, from the booklet question itself, you might feel that, sir, I don't agree with the answer. Now, there are two answers. We personally believe that both the answers are very close. One way of thinking is it is unsuccessful because the interference is reasonable. The other way of thinking is that she will be successful because it is unreasonable interference. Now, if you go to a village, there might be houses built near a flour machine. Now, does it mean interference? Now, there are two types of answers. Both are correct in a way, and at times CLAT or AILET provides two different answers. So it is a little tricky question, but we believe that both the answers, that is C as well as this C and this C, okay, there are two C's over here. This is also a correct answer. This is also a correct answer. Both can be inferred. Now, various questions in various types, there are different answers given to the same question. So, both these answers are correct. Now, what we feel at one time is different. What we feel on the other time is different, because having a floor machine, of course, it gives some noise. But does it mean that it is unreasonable interference? We also have been to villages. But no such things. People are staying on top of a floor machine house. Is that clear? Now, both this answer and this answer are correct. Now, it depends on the maker of the question. What does he think? Okay. So, there might be an answer that yes, it is disturbance. Somebody might say it is not disturbance. Okay. Okay. Both the two are correct. Both these two are correct. Generally, we feel that yes, she will be unsuccessful because mill is a source of interference. The amount of noise, which is unreasonable interference, somebody thinks it the other way. Okay, is that clear? Is that clear? Okay, is that clear? Okay. Moving on to miscellaneous law, international law. Some two questions on miscellaneous law. Pacta sunt servanda is a fundamental principle used in international law. What is the meaning of pacta sunt servanda? Treaties are rarely binding, treaties are binding, treaties are not binding, treaties are persuasive. Pacta means a pact, an agreement, a treaty between two or more than two countries. Sant, servanda means they are binding. So the correct answer is treaties are binding. Am I clear? So the correct answer is treaties are binding. Am I clear, all of you? Have I made myself clear? So the correct answer is up there, option B. Moving on to question number 2. Which of the following is not a primary source of international law? Article 38 of the ICJ statute, custom, convention, domestic law of the states. And the correct answer is very easy. International Court of Justice statute is a primary source of law. Custom is a primary source of law. Convention, customs, they are all sources of law. What is not a source of international law is laws of domestic countries. Laws of domestic countries are not valid primary sources of international law. Is that clear? Is that clear to all of you guys? Okay, fantastic. So guys, today what we did, what have we done? We have understood various laws by way of answering certain questions. And thanks to BYJU'S Exam Prep for bringing to you this particular marathon session. Now, before we say goodbye, tomorrow I will come live with another set of questions, with another episode of this marathon round. Do follow us. Do subscribe and press the bell icon of the page. Do like us on our Facebook page, join our Telegram channel, and do not forget to download the app from Google Play. Thank you very, very much. With this, we come to the end of this particular session. Thank you very much. All the very best. God bless you. Do like, do share this session with your friends. God bless you guys. God bless you. All the very best. And I'm sure that the kind of preparation you have done over the last couple of months, the kind of hard work that you have put in the last couple of months, you will do well. Don't worry. Have the confidence in you. God bless you guys. God bless you. Okay? Tata. Goodbye. All the very best. Take care, guys. Take care.